Thanks for staying with us here on Morning Live. Now, the National Assembly has passed the Recognition of Customary Marriages Amendment Bill, which will be sent to President Cyril Ramaphosa for his approval. Now, this is seen as a significant development in terms of women's rights and aptly timed as we mark International Women's Day today. And once the bill is signed, it will then mean that all women who are married under the Customary Marriages Act will be entitled to a share of the joint estate either on death or the divorce of their spouse, unless a different legally binding agreement was drawn up before the marriage. And joining us now to discuss this further is Moremadi Mabule, who heads up the World section at Sanlam Trust. Thanks so much for your time and welcome to Morning Live.
Good morning, Sakina, and thank you so much for the opportunity and for the invite.
Moremadi, let's start at the beginning and let's start by explaining what a customary marriage is. And of course, how is this different from any other marriage, like being married under a different contract, like in community of property or having an anti-nuptial contract?
All right. So customary marriage, Sakina, is one of the recognized marriages in South Africa. And there was a customary recognition, customary recognition act that came into effect. And it came into effect in the year 2000. And what it said in that act, it actually defined in terms of how do you set up a customary marriage. So there's 3 requirements that needs to be met, and those are tabulated in the act in terms of Section 3. And they are quite clear. It says, the marriage must be negotiated, it must be entered into, there must be consent, and it must be celebrated. And once those requirements have been met, then, that type of a marriage will be recognized as a customary marriage. So your question is around what's the difference between it and a civil marriage, where somebody typically would be married in terms of civil law, in community of property. So customary marriage, according to this act now, actually said, these marriages that came into effect post-2000, the 15th of November 2000, they are seen as also in community of property. That's their default. But prior to that, the default was out of community of property. So those are the 2 differences. However, you also mentioned in terms of the accrual system, that is another element in terms of a civil marriage, where you can actually sign an anti-nuptial contract, or you can go enter into a marriage completely out of community of property. However, the same act that I'm talking about, Sakina, in terms of customary marriages, further gives the opportunity for the parties in this marriage to also enter into an anti-nuptial contract.
So, and I'm trying to take it slowly, so we are all following here. So if someone has been married under the Customary Marriages Act of 1998 prior to this new bill, how is this going to affect the marriage?
All right. So prior to this new amendment bill, now let's take a step back. Let's take it to the year 2000. Marriages that happened after the act itself, which was from the 15th of November 2000 up until now, this new bill, those marriages, the default was in community of property. And in the act itself, there is a problematic section, which is Section 7.1. Section 7.1 said, this is only applicable to marriages that came into effect at the beginning of this act, meaning marriages that were prior. We call them the old customary marriages. They were now, excluded from this protection. And the protection here, it was that obviously now women are have the equal right of ownership, while prior to the act, women didn't have right to ownership.
So why is the current Customary Marriages Act inconsistent with the Constitution and its provisions?
Yes. So hence I highlighted that it became problematic. And we've got two, groundbreaking cases that actually forced Parliament to get us to where we are here, where we are now. And it's exciting times, I must say, that, and it is a groundbreaking, achievement, a milestone, because now the Act was protecting those in this case, and then it was excluding those who are the most vulnerable, those who were prior to the Act, and they didn't have ownership. And the problematic part is that it was inconsistent with the Constitution, because now women were excluded in terms of them being women. They didn't have the right to own. They were just not protected. And these two cases, when they were taken up to the Constitutional Court to be confirmed, the Constitutional Court actually said this is inconsistent, and therefore, hence, we needed now this to be rectified. And yes, fortunately, it has been rectified, and that's why we are here. It has been signed into law.
So there was a time, and I don't know if this is still applicable, when bigamy was actually a punishable offense in South Africa. So is that still the case? And how does this factor into that whole scenario?
Yes. So I like your question, Sakina, because in this scenario, what I was actually also explaining and what needs to come out is that this is a significant, milestone for those in polygamous marriages. So in South Africa, we do recognize polygamous marriages, and prior to this bill, the wives in polygamous marriages were not necessarily protected because they fell. Some of them fell within the prior to the Act itself, and now all women in customary marriages, whether it's polygamy, it's monogamous, they are protected in terms of proprietary rights, and which is, it brings back the dignity, and women are able to actually now also participate in the family property and co-own it with their husband. So yes, polygamy is legal in South Africa.
So once again, the timelines become important because, many will know whether this bill is going to be retrospective. How is it going to work? Do we know at this stage?
So at this stage, the bill is going to be retrospective. Remember, it's correcting the error that was actually made in terms of that Section 7.1 of the Recognition of Customary Marriages Act. Therefore, it's going to happen in retrospect. However, not for the estates that have already been wound up and not for the divorces that have already been finalized. You can imagine, otherwise we will have things, people wanting to untangle things that already have been, resolved. But it will actually, happen in retrospect.
So, Moremadi, I would imagine you've seen quite a bit of these disputes as you've been dealing with customary marriage disputes in your line of work. Tell us a little bit about that.
Yes.
What usually ends up being the main points of contention?
Yes, I think, Sakina, one of the main point of contention has been people not understanding, the default marriage system. Meaning, if you are married in terms of customary marriage, what does that actually mean? Is it in community? Is it out of community? That has always been a very dodgy. People, hear all these stories. They take whatever advice that they take from, and that has always been, a confusing story. However, there's also an element, that I want to emphasize is that people would enter into a customary marriage, decide that this thing is not working out for them, move on and accumulate assets. And when they pass away, guess what? They never got divorced. They are still married. And those are challenges because you find that the one spouse has accumulated so much, hoping that they have moved on and they're protecting this for their children, only to discover that now you still have that spouse. And if the default is in community of property, that spouse has it's the right of ownership to their half share of their matrimony. So we deal with those kind of challenges most of the time. Another point is people say, how do I get divorced out of a customary marriage? And it's you would actually think you can't just walk away because it is a marriage and it is recognized. Only the court of law can actually dissolve it. So you need to approach the court to get divorced.
One can just imagine, some of the very rich and interesting conversations that are going to flow from this in terms of, how do you recognize a customary marriage, which you pointed out right at the beginning of this conversation, and what constitutes a marriage. But is there anything that anyone who's been involved in a customary marriage has to do now? Or can they just sit back and it will naturally assume that it is now a marriage in the terms that you have described?
So I think, Sakina, that's a very important question. The Act itself says, how we need to register these marriages. And that's where, it gets very clear in terms of, there was a window period to say, we recognize your marriages, now come and register them. And people didn't go and register their marriages. We hear a lot of stories where people register after somebody has passed away or whatever. Whether that happens or not, you just wonder how legal is that. But people do it, as an after because they are dealing with an issue. But what is important, the Act says you can go and register your marriage. And then in that event, you've got an opportunity to actually get out of this. You can register it with an anti-nuptial contract. You can protect your assets so that your personal assets are protected from the matrimonial regime. So that is one of the things that people can do. Another point, Sakina, that I want to emphasize is that we need to get to a point where we protect our assets by drafting last wills and testaments. And by doing that, you are able to actually now exercise freedom of testation and say, here are my assets. Yes, I'm married in terms of customary law. Perhaps I'm married in terms of a polygamous marriage, but this is what I want that must happen in terms of my assets. And particularly with women, they have been not open to having these kind of discussions. And I think, it's about time we also empower ourselves and go out there and actually know how to exercise some of these rights. Freedom of testation is a right that is available to everybody. And people are just not exercising it, which is very concerning. I mean, if I give you the stats in terms of the working population in South Africa, the statistics are saying 70% of the working population doesn't have wills. So how about people in the rural areas? This information is just not lending, yet we are accumulating assets.
And we see the disputes every other day. But Moremadi, now,
Absolutely.
Just in terms of having these marriages registered, so, for example, if someone is married to Sakina and we have a civil union, so we have this marriage that's already registered, and now he decides he's going to marry Moremadi in a customary marriage.
Mm-hmm.
So, whose responsibility is it? Do the two of you, Moremadi and our common husband, have to go and register this marriage together, or can it just be done by one spouse?
So I think let's take one step back, Sakina. So if you are married in terms of a civil marriage, and then now he wants to get married in terms of a customary marriage. Remember now, the Act here is trying to protect that we all have equal rights. In the first place, Sakina now is in a civil marriage, probably accumulated assets in community of property, depending on how you guys registered your marriage. And now here comes a third party, Moremadi, to come and join the community. And it is advisable that now, as Moremadi comes in to join the community, what needs to happen is that now her marriage it needs to be also registered in terms of customary marriages, and we need to sign an anti-nuptial contract so that we protect each other's assets. Who needs to go and register? The Act says, parties can approach the Department of Home Affairs to go register it. And like I said, I mentioned that people go as an after effect. Maybe somebody has passed away, whatever. And in that case, obviously, there's only one person going. but whether they register it, I'm not too sure. However, if we are both alive, we go there and we register this marriage. But, then it means Sakina's civil marriage also needs to, you can't have a civil marriage and a customary marriage existing at the same time.
So what does that mean then for Sakina's marriage?
So Sakina's marriage, you need to approach the court to change your marital regime. You change it, you can actually, I don't call it a divorce because they don't necessarily get divorced, but you approach the court, you change your marital regime, then we both are going to be in customary marriages. Your assets probably are going to be divided in terms of your marital regime, the former marital regime, and then now we've got the new, both of us on an equal footing in terms of customary marriages.
So what if Sakina refuses, Moremadi? Does that mean then that our common husband needs to divorce Sakina in order to marry Moremadi, or how does it work?
So polygamous marriage, one of the requirements, Sakina, is to get consent from your wife. So in that case, it means now, as the common husband, you've got a challenge, because you need to get permission from your wife to get married. You cannot do it, and we hear a lot of stories of people doing it behind each other's backs. But then the question is now, will that marriage be recognized? And in most cases, when the popo hits the fan, that's when the husband dies, then, there's always challenges that, is this one married or not married? And we hear those stories a lot of times.
This is so interesting. This is going to be such an interesting new branch of law. I tell you, I'm thinking of up-and-coming attorneys. This is such a wonderful field to specialize in.
It is.
It's going to be
Absolutely.
very interesting as time goes by. But Moremadi, here's a question coming through. It says, what happens if someone was married traditionally before 1994?
So somebody who was married in terms of customary marriages before this act, so now in this case, they say before 1994, meaning it was before this act. What happens there, the default marriage then is out of community of property. And that is the one that we are saying, it has always been very problematic. In that case, women in those marriages did not have any rights in terms of right of ownership. Proprietary rights didn't exist in those marriages. They were actually seen as part of the subjects or the children in the house, the man being the head. And hence now this was challenged now in terms of, these two cases, the Gumede case and the Ramuhovi case. They were challenging that, you cannot exclude us from this act, while we know prior to the act there was a challenge. We did not have an equal footing with our husbands.
Speaking of equal footing, what about Sakina wanting to marry more than one husband, even if it be in the customary sense?
But is that customary, Sakina?
But are we not equal before the law?
I think that is a good question, but is it in terms of customary marriage, particularly African customary marriages? I'm yet to see one where, a woman is allowed to do that. And that's where we bring the Constitution and we say, constitutionally, is this even correct?
But
so it's an interesting, I think we're living in interesting times.
We certainly are, because there are tribes, may not be here, but who knows, if someone then decides that, I want to, what do we call it when a woman has more than one husband? What's that word? Leanne's going to Google for us while I'm finishing the question, where I did decide as a woman that I actually also want to be in a polygamous, polyandry is what it's called, polyandry. And if I want to then, as a woman, be in a marriage with more than one man, can the Constitution deny me that if it says that we are all equal before the law?
So, that would be very interesting, and it's a matter that the Constitutional Court is, can hear. And you can easily argue it to say, but how is that fair that he can get married to 2 women? I want to get married to 5 husbands. And this matter can be taken to, because when we're talking about the Constitution, then you can bring it in terms of the rights of equality and discrimination. Why am I discriminated? But I'm yet to see a case like that. I haven't come across it in South Africa. I don't think in terms of African indigenous law there is. I'm not sure how the Reign Queen works, because she is the queen, and then I'm not sure if she's got husbands or how does that work. But I'm yet to see a case like that. I haven't come across it.
Interesting times, and it is, of course, International Women's Day. Happy Women's Day to you, Moremadi. Thanks so much for speaking to us.
Happy Women's Day to you too.
Moremadi
Thank you
Mabule.
so much, Sakina. It was lovely chatting to you.
Absolute pleasure. Moremadi Mabule is from Sanlam Trust, talking to us about the importance of Parliament passing the recognition of Customary Marriages Amendment Bill, and specifically relevant on this International Women's Day, Leah.
Oh my gosh, polyandry.
Yes.
I'm sure she has had no requests. I couldn't imagine it. Just one. One is more than I can handle, more than enough. Anyway, you know how many questions are coming through and how many comments, as one can only imagine. So, listen, thanks for watching. We'll read a couple of these comments and perhaps, get some questions through to whoever can answer them, because it's really an interesting topic.
I think we should talk about it a little more. As I said, it's going to be such an interesting branch of law to specialize in, because you're going to have to be au fait with all the various customs and what these customary marriages would entail. But it's fascinating. But
really
this is where we have to leave it with our SABC viewers, unfortunately. Until tomorrow, please take care.
See you tomorrow, everybody. Bye-bye.